10 years ago, the Ninth Circuit Court of Appeals issued a landmark ruling in SmithKline Beecham versus Abbott Laboratories, declaring that discrimination on the basis of sexual orientation in the jury selection process is unconstitutional. A decade later, the Ninth Circuit remains the only federal jurisdiction to explicitly protect LGBTQ+ jurors from being dismissed from jury service due to their sexual orientation.
SmithKline didn't start out as a case about LGBTQ rights. It was an antitrust lawsuit between two pharmaceutical companies alleging predatory pricing of an HIV medication. However, during jury selection, Abbott Labs exercised a peremptory challenge to strike a male juror who had referred to his male partner during questioning.
During the jury selection process, which happens before a trial begins, attorneys can dismiss a limited number of jurors without providing a reason for their dismissal. This is called a peremptory challenge.
In 1986, the Supreme Court's decision in Batson versus Kentucky established that under the Equal Protection Clause of the 14th Amendment, attorneys could not use their peremptory challenges to dismiss jurors based solely on race. Under Batson, if racial discrimination is suspected, that attorney must establish that their strike was for a racially neutral reason, otherwise that juror will not be dismissed. In 1994, the Supreme Court extended this important protection to also guard against discrimination on the basis of sex.
In SmithKline, the plaintiff argued that the 14th Amendment should also protect jurors from discrimination based on their sexual orientation. The judge overruled their objection, so the plaintiff appealed to the Ninth Circuit Court of Appeals.
At that point, Lambda Legal decided to file an amicus brief in support of the plaintiff, arguing that peremptory challenges based on sexual orientation violate the Equal Protection Clause, because the heightened scrutiny standard that the Supreme Court applied in its 1986 ruling in Batson should also be applied to sexual orientation.
In 2014, the Ninth Circuit issued its decision in the appeal. The court ruled that classifications based upon sexual orientation must be subjected to heightened scrutiny, and that using peremptory challenges to strike potential jurors because of their sexual orientation violates the Constitution.
The Ninth Circuit ruling was groundbreaking because it provided the first federal protections for queer jurors in the nation. Those called for jury duty in the 9 Western states now cannot be discriminated against based on their sexual orientation in performing this important civic duty. In addition, the Ninth Circuit held that discrimination based on sexual orientation should be presumed to be unconstitutional and should be closely examined by the courts. I'm also proud that Lambda Legal's brief was joined by numerous non-LGBTQ groups, including MALDEF and the Asian American Justice Center, who agreed that queer people deserve to be protected against discrimination in jury selection, just as women and people of color are.
Despite that victory, 10 years later, justice is stalled. SmithKline remains the only federal protection against discrimination on the basis of sexual orientation in jury selection.
Because a case similar to SmithKline has not come before the U.S. Supreme Court, and there are no federal protections against discrimination on the basis of sexual orientation or gender identity in jury selection, outside of the Ninth Circuit, there are no protections against this form of discrimination unless they've been enacted by individual states.
Some states have addressed this inequity by passing laws protecting LGBTQ+ jurors, ending the practice of peremptory challenges altogether, or following state court decisions that protect against anti-LGBTQ+ discrimination. But there is no uniform solution and no overarching federal protections.
A fundamental pillar of our justice system is the right to a trial before a jury of your peers. This, however, means nothing if only some people have access to jury service. Not only does denying LGBTQ+ people the right to serve in juries blatantly undermine the fairness of our system, it also denies us the opportunity to participate in the administration of justice. Jury service is an important civic duty for Americans that reinforces our common values of fairness and equality and liberty and justice, and LGBTQ people deserve the right to engage in that important civic work.
Especially with rising efforts to criminalize aspects of LGBTQ+ lives, it is essential that we are empowered to serve on juries to ensure fairness and representation in the justice system. The SmithKline case was an important step forward. Now, a decade later, it's time to protect LGBTQ+ jurors across the country. The National LGBTQ+ Bar is proud to be a leader in this movement, and we invite you to learn more about jury access on our website.